So today's legal tip is you need to add a buyer. But before I give you the answer of how to do that, have you ever thought about how many nerds are on your contract committee? The answer is quite a few, and I'm one of those proud dirt nerds. This legal tip here this week comes from one of our little dirt nerd conversations where Tracy emails me, Becky, and John about this thought she had and how the best way to do it. And next thing you know, we have like 17 emails back and forth pontificating on how the best way to do it is. This is a regular occurrence between us dirt nerds. So I guess you should feel comfortable knowing that you have a bunch of nerds on the contract committee that really sit around and think daily about weird scenarios on the contract and how we have to resolve them. So hopefully that will give you some rest at night knowing that somebody's out there trying to figure all this stuff out for you. But yes, we're dirt nerds and we really are proud of our nerdship. Now, what is the answer to the question? The question really is more of how, not a how, but a why. And I think the problem here is that you have one spouse on the contract and they want to put the other spouse on the loan. So they'll have the husband and wife will be on the loan and so the lender says, oh, we need to put them on the contract. Well, the question is why? They don't need to be on the contract. The contract is your legal obligations and your right. It's your opportunity to sue when the other side defaults or to be sued if you default. So they don't both need to be buyers under the contract. One spouse could be the buyer and then they both could be on the deed and thus on the loan. And so when the lender says they need to be on the contract, we need to amend the contract, they really don't. What they need is they need to be amending in the CCRA contract, paragraph 7. And yes, this is how big of a nerd I am that I keep copies of the contract in my desk. Or if you're using the contract for the state, you'd be paragraph 4. Okay. And so what I'm getting at here is under paragraph 7, it's how does the names, it says the deed will be prepared in the names of blank or as otherwise stipulated by buyer. So quite frankly, in the CCRA, you don't even need to amend the contract to add the name. But if the lender wants to see the name on the contract, you would just amend the contract to add that. Or in paragraph 4 of the state contract, it's a little bit different. It says the deed should be in the names of blank and ownership type determined by buyer. Well, unfortunately, it doesn't say or as buyer direct. So you would have to amend that. So the answer is they really don't need to be a party to the contract. But if your lender is absolutely demanding of that, then there's two ways you can do it. One is you can do it on the face of the contract. I've seen people do this all the time. They just take the face of the contract, add the other party, have both parties initial it and date it. Or they can do an addendum saying the contract is hereby amended to add spouse B to the contract. Now, understand that once the spouse is added to the contract, all those rights and obligations applies to the new spouse, just like the first spouse. So everything in that contract applies. It doesn't change any dates. It doesn't change anything. Everything still applies. They also now have the ability to be sued as well if they go into default. So they need to understand that. But also, and very importantly, is that you have an obligation to explain all of this to the spouse that's being added or to the party that's being added. It doesn't necessarily have to be a spouse, but make sure that you are explaining the new buyer all their rights and their obligations. As an agent, you have fiduciary duty now to that new buyer to make sure that they understand all those rights and obligations. All right. Hopefully that answers your question. I hope you have a great weekend.